We have a new. New Oh. Good evening. Welcome to the Zoning Board of Appeals for the Town of New Canaan. In accordance with Connecticut state statutes, this meeting is being recorded and will be available on the town's website later this week. Please silence your cell phones during the proceedings. Agenda items will be called in the order listed on tonight's agenda. When your application is called, applicants should come forward to the table and ensure the microphone shows a green light. Any members of your team participating via Zoom should turn on their video. The applicant will present first, providing a summary of the proposed plan and explaining the hardship related to the property. Please note that a hardship must be physical in nature and must be unique to the property. Following the applicant's presentation, the board will hear from members of the public, first those present in the room, then those on Zoom. You must state your name and address before speaking. All comments must be directed to the board, not to the applicant. Once public comment is complete, the board may ask the applicant additional questions. Applications will then either be closed or continued to a future meeting night. After closing the matter, the board will deliberate and may vote. The first matter on the agenda tonight, continued 995 South Avenue, zoning variance upon application of Andrea Gomez, Squire, Hinckley Allen, authorized agent for 995 South Avenue, LLC. Owners for a variance of sections 3.5 E2 to allow the reconstruction of a single-family structure 22.2 feet from the front property line and the reconstruction of a two-family structure 28.1 feet from the front property line in the 2-acre zone at 995 South Avenue, map 30, block 52, lot 4. So the public comment closed last meeting. This is business session. So Chad, you can't speak during the business session on this one. All the regular members of the board can speak. Does anyone?
I'll start. Yeah, so I struggled with this one, but I think I reached a decision going back and forth. You know, I understand the grandfathering of the two family being allowed. It's just the surrounding area and neighborhood. You know, having what is proposed, it's nice, it's, modern. To me, it just doesn't fit in. And, I took a look at the same type of housing across the street from the Rowayton Fire Station, in Darien. And it's sort of that look, which is kind of doesn't fit in that area. So while I appreciate, the grandfathering of the two family, I think in today's rules and the intent in today's laws, probably not to allow that. And I think I understand the owner has the right to the two family, given that it was there before. I think for that privilege, he's got to abide by the law and the regulations to the T for that right. Because I really think a two family doesn't belong there if it wasn't for the grandfather. So I'm inclined to vote no on this, in my opinion.
If I can just add in regard to where you're talking about the neighborhood, and I know that in the memorandum from I think Sarah and her group, it listed all of these other properties where there were two families built. I think when you look at the neighborhoods, Forest Street, River Road, or River whatever, they all, you have those two-family duplex type of
Right.
neighborhoods where I see that fitting in more than at 995 South Avenue. I have to agree with you there. The other thing is that I know, looking at the people that were presented to be in favor, of the building of the two-family and the single-family, the condominium complex on that property, none of them are in that neighborhood. There were 10, letters or 10 people that said, okay, that they were in favor of building it there, but, they're not even located, as opposed to the 28 neighbors, who are right in that neighborhood that are opposed to it. I mean, I'm kind of where you are, Rich, you know, in thinking that could a single family home, beautiful home, be built on that property and fall within whatever the guidelines are? I didn't feel that that was ever presented to us. You know, that either or,
Right.
you
And-
know.
And again, rich character, you know, Cynthia, yeah, and neighbors the immediate neighbors suggested, you know, a one-family house would probably do much better there. Yeah, I think what happens is now we sort of incentivize for folks driving around finding, oh, I'm not gonna call it a loophole, but you know, a two-family that was grandfathered and then, you know, try to put in another two-family and, you know, benefit monetarily from that. So I think if you want to take advantage of the grandfathering concept, which I understand, you got to do it within the law, in my opinion. But Cynthia, I hear you and I agree.
I mean, this is Jessica Cardin, to sort of knit against that, I will say, you mentioned Forest Street. I live on Forest Street, so I am very aware of the development going on there. Plenty of people are taking advantage of multifamilies and actually putting up very tall, single-family houses that you could argue are adding value to the street, but also are changing completely the look and feel of the street. One of those developments is not far from where I live, and I question some of the heights myself, but you know, I know the process here, I know how diligent it is, but I also look at what is across from me, which is really lovely multifamily homes that probably for the time were akin to what this development is proposing, where they are, you know, bigger on each side than my own house, which is a standalone home. I think they're probably 3,500 square feet on each side by side townhomes. You know, my view here is there is always going to be change. What currently is there right now is definitely not attractive. And, you know, they're looking to do things, you know, just to sort of say like change and evolution happens in town. Part of that is because of change zoning rules, and they are still under coverage. They're not asking for a coverage variance. So what they're building, they're permitted for the lot size, theoretically, at least based on size. So if it's a size appearance change, that would be no difference if they put a standalone home. It would be a massive standalone home. You know, maybe it would be easier for people to make a decision based on that if they saw what a standalone home looked like compared to the current plan. But to me, they've actually made a lot of steps to try to actually move the plan back. So it's actually going to stand back further from the road. They're trying to improve sight lines. It isn't really that much more traffic ingress and egress compared to what could go there. You know, there are multifamily homes that have so many maintenance workers, nannies, individual cars, multi-car garages that I don't think you're really comparing much different as far as the traffic addition. And they didn't have to do a traffic study. It does not impact that as well. So to me, the ask, they're actually trying to improve some of the variances that exist in the property right now. So I guess those would be kind of the pros for the plan.
Yeah, I took a look at it, Alex Snyder here, on a couple of different levels. I wanted to think about it. I think I hit it a little bit the way you first did, was before coming to, is this piece of land, is there hardship here? Is it suffering from something unique? I thought about, this is literally one of the three main gateways into New Canaan from the south. There is Ponus Ridge on the west side. There's South Avenue coming from Mansfield in the center, and there's Smith Ridge 123 on the other side. Those are the three gateways in. And this is the first lot that you see coming in. And when I think about a piece of our mission as a board and focusing on the overall zoning picture and the aesthetic of the town, that was kind of one of the first things that I thought about as I wanted to kind of color my analysis looking at the facts. The second one that I thought about, the traffic study was interesting, but more interesting to me was the erosion of the setbacks. And I know that they tried to show places where there was more setbacks. But in fact, when you dive into the two new footprints, you have substantial amounts of those structures that are now closer to the road. And I know one of the neighbors brought up the traffic accidents. Setbacks are important from a public safety perspective on a state highway, both in terms of cars actually hitting a structure and then for first responders to actually be able to be there and have them safely getting out of the road and getting to the structure. So those are actually two things that I thought about even before getting to the question of whether or not there's a hardship based on the law.
Mr. Snyder, for the record, could you just clarify your statement about the structures being closer to the street?
Sure. I mean, I can look at when I went through, I compared the outline of current structure versus the proposed structure for both 985 and 995. And there are portions of what's going to be the new structure that are inside the setback that weren't there before and that are closer to the road.
Are they, because my understanding of the application is that they're moving the structure back from the,
I think what you're
Property
saying,
line?
certain areas you're saying are more forward, even if the closest point is further back. I think that's what you're saying.
okay,
Yep.
so just more mass, basically.
More mass.
Okay.
Closer
Yeah.
inside the setback.
Okay.
Right, that's a good term. Yes, the term.
Mhm.
Cynthia Dell, to that point, I think that the structures that are there right now are kind of tilted. Whereas from my understanding, looking at what they're looking to build, the whole front of the structure is now there as opposed to the tilting and
They kind of squared
placement.
it more.
Exactly. I do have to agree with you. I think that that's really a very precarious corner there. I mean, I know myself coming off Stephen Mather or even off Talmadge Hill. I mean, people come around that corner quite fast. You know, I know there was no traffic study done. I don't necessarily think that this is going to add to it. It's already a dangerous spot from my perspective.
Yeah, for me, it's just the part of the policy of public safety with setbacks is any kind of, once again, it goes to these nonconformities, even though the existing nonconformity is there and it's legally. The idea is hopefully they're not going to continue in perpetuity or get worse. And as they admitted themselves, there's still an additional 160 square feet of expansion into the setback area beyond the nonconformity that currently exists.
I think I would argue, just as another devil's advocate point, Jessica Cardin. I think at one point they said that they might even be able to push for a through family. Is that correct, Sarah? That there was maybe potential evidence in the car that they could push for a 3-family. Is that true?
So, no, so there are, so, you know, they're proposing a 2-family and a
Right.
1-family home. There was, when they first purchased the property, they thought that that there were 4 units. And there was a bit of a gray area in the information that they submitted that if they dug further, they may have been able to prove that there were 4 units, but they chose to just move forward with the 3.
But they still could theoretically. try to dig.
Theoretically.
Okay. So the only point I would want to make is that even if the 2-family / 3-family right is established at a bare minimum. So even if this particular application was denied, it doesn't mean that people in that neighborhood are going to get what they want in a single family home. They could still come back with a 2-family home opportunity that is quite sizable. So while I agree, I don't know that it's necessarily in our legal purview to look at the aesthetics of plans and try to guard the aesthetics of the town per se. But if we're looking at hardships and things like that, any plan they come back to, they haven't exceeded coverage even with this plan. It's still going to be a sizable plan. So if we're looking at it as, oh, if we deny this one, they'll come back with something smaller, that's not necessarily true. So I just keep that in mind, I guess, as you're evaluating it. If it's a coverage issue, they didn't even exceed it right now.
So I started looking at this more based on the law than the characteristics of the property. And the memorandum from January from town council on like the variance stuff, I think that's like a really good basic outline of the conditions under which we can grant them. I used to just primarily look at Verillo, but I think this is a good summary. There were some parts of it that I looked at, but I think a lot of it became kind of irrelevant based on some of the discussion of the last meeting. But in this outline, talking about ENF Associates versus zoning appeals of the town of Fairfield. He talks about how in that case, there was no evidence in the record that the strict application of regulations would have a confiscatory effect. The Supreme Court concluded that based on the previous holdings, that proof that a property has a peculiar characteristic that makes it difficult for a particular use to comply with the zoning regulations does not justify the granting of the variance when the owner has made no showing that the property could not reasonably develop for some other use permitted in that zone, or that the effect of limiting the parcel to the permitted use only would be confiscatory or arbitrary. Again, citing the Supreme Court in that case, the Stillman decision the Supreme Court said the Stillman decision is inconsistent with the Supreme Court cases holding that when a property would have an economic value, even if the zoning regulations were strictly enforced, the fact that a peculiar characteristic would make compliance with the regulations exceptionally difficult does not constitute a ground for a variance. The Supreme Court repeated once again that the power to grant variances must be exercised sparingly. And then he kind of summarized the discussion by saying the Supreme Court has now made it clear that if a property has economic value, showing that the property has a peculiar characteristic so as to make compliance with the regulations exceptionally difficult is not sufficient to justify the granting of a variance. It's clear from the case that the economic value of the property without the variance must be an element for consideration by the zoning board of appeals. In other words, variance should not be granted if a property continues to have economic value in the absence of the variance. On a typical case of a property owner with a 3-bedroom home who seeks an addition within the setback because there are wetlands on the opposite side, no variance can be granted since the 3-bedroom home still has economic value as is. And I think that kind of relates to what Jessica just said, that they could build maybe even more units on that property. They would just have to stay within the footprint. I don't think that property has no economic value if this isn't granted. I went back to Verillo. I looked through that case. Again, quoting the Connecticut Appeals Court in that case, they said during the public hearing, the board's chairman summarized his interpretation of the applicant's request as follows. What I'm hearing from the applicants is we have a structure that is old, it's falling apart, it's in need of major renovations, regardless of whether it gets expanded or not. But since we're going to go through all that, we might as well, rather than to maintain the status quo, we're going to ask for permission to improve it and enlarge it somewhat. That's what I'm hearing. That observation aptly summarizes what this case is about. A variance is not a tool of convenience, but one of necessity. They are to be granted when the strict application of the regulations results in unusual hardship peculiarly affecting the property. They are not to be granted when a reasonable use already is present or plainly as possible under the regulations, but an owner prefers otherwise. So I think that's the general law. And then I move on. I found Rich's questioning at the last meeting. I went back and listened to the recording again on it, of where he went into whether or not they could make any other use. And he asked, can you build on the existing same footprint without wetlands, board of health, or other issues? Can you put in a septic and other items and stay within the footprint? And if you can put in a brand new 1 or 2 family house in the same footprint and comply with the wetlands and septic, then is what you have to do, because that is what you bought. I mean, I'm kind of quoting / paraphrasing him, but I think that kind of summarizes a lot of the law. Attorney Gomez then asked Justin, I don't remember if he was the engineer or the architect, but asked Justin, who was on Zoom.
He was the engineer.
The engineer.
Yeah.
Can you build, quoting Andrea, can you build in the same footprint as the existing buildings and comply with all of the retaining walls, septic system, stormwater, soil erosion, sediment and erosion control requirements from the regs, CTDP, CTDPH? Could you comply with all that with building in the existing footprint? Or would there be issues with that? And Justin said, I suppose you could. Or suppose you could find a way. So I don't think they have a hardship because they're admitting they can build it there. And comply with all the requirements if they stay on the footprints.
I think there are some hardships though that run with the land as far as the grade of the property, the wetlands. It's kind of an unusual shape of the lot with respect to all of that. I mean, the fact that the current structures are already violating, certain parts
Well,
of
that's like a
the
different
zoning.
grounds. like
No,
making
I
more
know, but I'm just
compliant.
saying, like, I think if we are valuing the fact that they're so under coverage, if you want to look at how are they supposed to kind of make the most of the coverage without a variance when there are these unique characteristics to the lot?
I don't think making the most out of coverage, though, I don't think that's the inquiry. So then,
But then aren't you denying them a certain amount of
But-
value with the land?
but maximizing value isn't the point. You're not
I'm
confiscating the
not saying
land. It's-
maximizing, but at this point, they may not even be able to take advantage, like to their point, I think it was a developer who said, I wouldn't be able to actually rebuild the smaller unit,
No.
the smaller, like 600 square foot
That's what
structure.
I was gonna go on
And do
to.
anything.
So then the developer then came, so then the architect asked, would you have to make the building smaller to comply with all those things? And he said, you would most likely lose the basement. And then the builder came on and said, that he'd be forced to build within a 768 square foot footprint on the northerly structure. But, and I feel like might not be a huge house, a 768 square foot footprint, but that's the size of my house. My house is 1,600 square feet with no basement and no attic. I feel like that's a livable house. I feel like staying within that footprint is not a taking. It's not saying you can't build something there. We've had properties where to build a house, you'd get like a 10-foot wide structure. It's impossible. I think it might not be maximizing his profit, but I don't think that that under the hardship test, there's a hardship on this property. Because they can make reasonable use out of it and they're not losing value. He bought it for what he paid for. He can build on it within the footprint. Might not get to build exactly everything he wanted, but that's what comes in. So then the next thing I looked at, because then,
Could I just,
Yeah.
before you hit, just because I want to just follow through, I think, on your point there, which is the applicant made a point of saying he did his due diligence. He's very sophisticated. He made a point of bringing his experience. He's a redeveloper who carefully looked at this land and made a business bet, looking at all the challenges and what he would want to do and what he could try to do. And I think the law is really clear. You can't get everything you want necessarily. You've got the land and it can't be the perfect house, the most modern house. There's been plenty of cases on that, but it is buildable. And the burden of proof is on the applicant to say, I can't build here. And they didn't come close to that.
I believe they acknowledged they could still build something there. He was asked if he, ever studied making a smaller house. He said he hadn't. This is just what they went with. I mean, it's hard if they haven't looked at another option to say this is the only option. I felt like at the last meeting, the testimony was, it took the hardship off the table for me. I mean, it really did. I don't think that's the end of the analysis though, because the second point, which we also discussed at the last meeting, was a decrease in nonconformities. So, if there's a decrease in nonconformities, it's not like a hardship where you have to grant one, but the board may grant one. Again, this is discussed in this memo. In the, just quoting, it says, these cases do not mean that a variance must be granted every time the applicant claims it's relating a nonconformity. Other factors, first, the impact with the surrounding area. Second, whether the change will be in harmony with the general purpose and intent of the regulations. And third, due consideration of public health, safety, convenience, welfare, and property value should also be considered. So I think that even if they don't get it under the hardship, I think there's still these factors, because at least in some respects, they're reducing the nonconformity. Some areas there may be increasing it. I went back and looked at both of the neighbors. The presented materials had some images similar to this with the
Yep.
with the picture around it. I wasn't quite sure what to make of it at the last meeting because there's no scale to it. There's no anything. I don't know what this box is. I think Jessica brought up that point, is how do we know what this is? I tried, at least from a rough standpoint, not from a standpoint of granting a variance, but a standpoint of seeing if this picture is representative to me. I went back and I measured the windows on the two structures and tried to scale things based on the heights that we have. And I came up to their boxes being within a foot, then like of what I think. So I think this is representative. It might not be exact, but they're not applying for the variance. The applicant could have come in with more precise heights, but I think this is pretty representative based on scaling to the items we know there, which for me was the window heights. And I could determine the building heights off the windows heights, because the house on the left, it's a 4-foot high window in the front. The one on the right's 4 feet 6 inches. We know the height they're building on their plan, so it didn't seem particularly hard to me to tell if this is relatively representative, and I felt like it was. And I think this just shows that what there's the problem with from the neighbors. It's kind of like what Alex said, is that the volume within the setbacks, like they're going from a much smaller structure that's kind of juxtaposed to the road to two really tall, big structures closer to the road.
I mean, that may still happen, Luke.
It might still
Unfortunately,
happen.
I mean, just with what they might be able to redevelop, because I'm gonna guess that they could actually develop much taller structures even on the existing footprint and not violate or even come in for some sort of variance. So rescuing that for the neighbors, that may just be something they have to
I mean,
get used to
they-
the
they're
idea of.
probably- They're probably
Just
gonna
to-
get bigger houses.
Just to
Jessica,
jump
I
in.
don't want to get ahead of ourselves, but I don't necessarily agree with you.
Could I
on the
jump
way I
in?
read Barilla, but I don't.
No, I'm not trying to make a legal assessment of anything. I'm saying, should this variance be declined today, like the request for it, whatever they come forth with a new application, it may still have I think it very likely would still have a very significant change in mass.
I mean, they're.
So
pretty
it's
close.
not something we would necessarily be, preventing.
Could I just jump in really quick about the footprint comment that Ms. Carden made? So essentially, what they could do with the I think it's the single family structure right now, they could completely tear that down. You keep the footprint, you could go up 2.5 stories, 40 feet tall, would not go to any board or commission. It would come just administratively, just so you all understand the context of what as of right could
If
happen
it stayed in the same.
in that same
Yeah,
footprint.
but
it
they're
would be.
proposing 37.30, I can't tell which one's which, but for one, they're proposing 35.3 feet. In the other, they're proposing 37.2, and I don't believe those are even counting the cupolas. So
Yeah,
they're not,
cupolas are excluded.
yeah, so they're already,
Pretty tall.
they're not gonna make it much higher than what they have here. It's gonna be within, a few feet. They're not right up against it, but they're pretty close to, it's not like we're looking at this and there's gonna be another story above it. So they'd have to stay on the footprint and I was saying that I think this is representative without really being precise. I don't think those two illustrations that the neighbors had were dispositive. They came up at the last meeting. So I think then,
I'm personally hesitant to accept anything that doesn't have a scale, but I can certainly see why people would want to look at it for some sort of illustrative.
In an ideal world, I would love to have had one, like in an ideal
Yeah.
world that everybody blessed and agreed on, it would have been very helpful.
but no one presented the heights. I feel like it's the applicant's application. They decided not to present the heights. I feel like, to me, it seemed relatively accurate to compare how high. I know this is 4 feet 6 inches high. I know how high this is gonna be. What is the building quoted? So then the question becomes about those three factors. Should we still grant one on the grounds of the impact of the surrounding area? Whether it's harmony with the general intent and purpose of regulations and consideration of public health, safety, convenience, welfare, and property values. That's kind of where I left off on my.
I think it's an
Analysis.
interesting issue that while they are reducing the setback in the front in some places, it is obviously intertwined with the fact that the coverage in that front setback is massively increasing. And I think that is a point that many have raised tonight as what the hesitancy is with the request for that variance. So
I think that.
I
goes
think
even
that is a
more.
hard thing to
I think
overcome.
that goes not even, that goes into the first question, are they making more conforming? Because maybe even if in some spots the number of feet is closer, maybe it's not really more non-conforming because of the volume in the setbacks or the area in the setbacks, but I was saying if I presume that they're making it non-conforming, I mean, more conforming. Did they satisfy those three other factors and the subparts of them? Impact with the surrounding area, the neighbors have presented a lot of evidence on that. I think everyone spoke about that today. Whether it's in harmony with the general purpose and intent of the regulations, I think a lot of people discussed that.
Mhm.
Public health, safety, convenience, welfare, and property values. Safety might be improved with the sight lines. Public health, whether or not they build any structure on there, they're gonna have to put in septic systems and drainage and things like that, and Justin commented they could still all do that while complying with the, staying within the footprint, so I don't think public health would drive this. Convenience, I'm not sure about that. Welfare and property values, the neighbors spoke at a few times about property values. Are they realtors? Are they experts? No, but I do think, someone who's lived in the neighborhood for decades probably has some idea of things that might affect their property values. And if this is the test, the applicant could have presented information showing that tearing down those two dilapidated houses fixes property values and improves these factors, and they didn't present evidence on it, so.
I think there's a chance that any new development there will help the property values, but I think the neighbors are more looking at would a two-family and a single family improve it as much as a single family?
Or I think they're looking at, would something this big improve it versus, you could have an apartment, a 600 square foot apartment. My neighbor has an apartment above their garage, it's less than 600 square feet, it's always rented. I mean, you don't need a huge apartment to be able to rent it. Not every house has to be huge, so they could still have, like you said before, they could potentially have 4 units there, a single and a 3-family, but it doesn't mean it has to be as big as what they're proposing now. And I don't think the neighbors are necessarily opposed so much of the rental versus the ownership, and I don't think that's relevant or something we should even consider. I think they're concerned with this really big volume so close to the road. I guess they do have the public safety things they mentioned as well about the cars there. They had the picture of the car hitting the tree there or whatever. That's my analysis. Appreciate anyone else's.
I mean, I think you've done an excellent job summarizing it in terms of each of the issues, what our role is, what they needed to prove, what the burden was under the law. And I do not see a reason to grant the variance, having taken all this into consideration.
Rich Carey too, I agree, as I stated before, and as you pointed out at the last meeting, I did try to get a hardship out of them by asking them, can you do X, Y, and Z with the septic and, wetlands, and, they did not present a valid hardship to me, so for that, and, the reasons I stated before, I'm a no on this variance.
Cynthia Dell, I read through a lot of what you did too. Obviously, I'm not a lawyer, but the documents that we were given to see whether there was something there that I might be missing, and not just basing it on the structures themselves, but I found it difficult to come up with a hardship. We don't need necessarily to have everyone building 5,000 square foot homes in town. There are people that are looking for smaller ones. I live in a smaller house myself, 1,500 square feet on a slab.
1,600 square feet.
And so it's not like there aren't people that are looking for smaller homes. I have to agree with what everyone has said, and I'm not necessarily, I'm opposed to granting the variance.
I would only say that I appreciate that they took time and effort to keep coming back with a revised plan. I think they did have a lot of discussions with the neighbors. I think they tried to do things in a very cordial way, which is always hard coming in as a developer, especially in a very well-established neighborhood. Seemed from the public comment that a lot of the people who live in that neighborhood actually respect what he's trying to do and respect him as an individual, the developer. They just didn't like this plan and what they thought the impact would be. So I do want to give them credit for all of that and the steps that they've done to work with Sarah and the team here and try to come back forward with a plan. And certainly a plan that never asked for more coverage than they were trying to, get with the zoning laws on the plot. I will say I was always a bit struggling with the amount of coverage that creeped into the front setback for which the variance was being requested. I think it is a pretty substantial change. I don't know if the characteristics of the lot justify that amount of change. And that would be really what the hardship would be that they're trying to put forth is the grade of the property, the wetlands and things like that. But I don't know if taking up that much more mass and square footage and coverage in the front variance and taking away, the little bit, pushing it back a little bit really makes that much of a, swap per se to justify in that regard.
Okay, so my view, I think I said it before, I don't see a hardship. I think they acknowledge that. And if they didn't acknowledge it, I think the facts are clear on the record. There's not a hardship. Despite the unique features of the lot. And we go through those other factors, impact with surrounding area, I'd say the project would have a negative impact. Based on the evidence presented, whether the change would be in harmony with the general purpose and intent of the regulations, I'd say it'd be negative. Due consideration of public health, safety, community and welfare and property values. After considering those, I'd say they're all in the negative. So I would also not be in favor of this application. Does anyone want to make a motion in favor of the application? No. Does anyone want to make a motion? I guess I can make a motion against. I'd move that the application be denied on the grounds that there's not a hardship and that there's not a decrease in nonconformities that would justify the granting of the property.
I second the motion.
Yeah, Rich Carucci.
Okay, unless you want to start voting since.
Dull in favor?
Cardin in favor.
Passion in favor?
Rich Carucci in favor.
Alex Snyder in favor.
Okay, thank you. Okay, does anyone need a break or you want to go on to the next matter?
Let's move on.
Okay.
Thank you.
Thank you.
Yeah, we
Good.
talked about that.
I think you gave me
I have one. Oh, I was about to say, I was.
Okay. So the next item on the agenda tonight, 45 Brushy Ridge Road zoning variance upon application David Rucci, Lampert Tutor and Rucci LLC, authorized agent for Gavin J. and Melissa G. Parker, owners for a variance of section 3.5 F5B to allow 12.5 square feet of second floor area to exceed the side yard height of 20 feet. 27 feet in total height, 25 feet, total height allowable 25 feet. Existing 31.8 feet in the half acre zone at 45 Brushy Ridge Road, map 38, block 93, lot 748. Did we get all the cards in?
Yeah.
Not the cards, but proof of mailing?
Yeah.
Okay. Attorney Rucci, do you want to present your application?
Yep, sure. Good evening, David Rucci, Lampertu and Rucci. This evening representing Gavin and Missy Parker for their property at 45 Brushy Ridge Road in New Canaan. Also with me is Carlos Diaz, the architect and the builders here as well, if there's any questions about that. So this property came about in 1984 from a subdivision. It's shown on map 6330 on the packet that you gave me, and it's up on the screen now as well. You can see on this that it's kind of a difficult lot to begin with. It's shared with an access way from Brushy Ridge Road, and there's homes off the access way itself. It's known as parcel 748 here, and it's 5.5 acres in the half acre zone. This is what it sort of looks like. You kind of come up this big hill on Brushy Ridge, and this one sort of sits right to the right as you walk on. You can see even as you come up here today, that it's still sort of sitting on this angle here. It slopes off to the, I'm sorry, to the south, and it slopes off to the north. Here's just a picture from the driveway, and you see the retaining walls kind of keeping it up on this little ledge here. So this is this is not actually the existing survey. In your packet, the existing survey, I had to swap it out because I realized I had misprinted. So look in what you have there, and you'll see from the survey, which is actually on this page here, that this was the original survey, and it shows you how they were going to do this addition on the property. And the reason I bring that out is because this is an after the fact variance request permit. And essentially what happened was the original survey was done. It was given to the architect. The architect developed the plan. It was then submitted in as far as the building permit when there was, if you read the town planner's memo, it's unclear. Initially, when it was designed, they didn't know that there was a second story setback because they were looking at it from their perspective, what the surveyor had done. The surveyor hadn't put on that second line. So when the architect developed it, he handed it to the builder, they put the building permit in, and everyone thought it was fine. They were building on the setback line. It was brought to someone's attention at some point about halfway through the process that, hey, you guys got to make sure that you look at the second story setback line because you may be over it to a certain extent. That obviously got lost in the shuffle here, one way or the other. But, you know, it was definitely brought to their attention, but how it was brought and where it was brought, and I think what was going on as far as the construction already done, it got lost in the shuffle here. So what it eventually ended up happening is, I'm just going to go through it as if we didn't have, this hasn't been built already, and that this would qualify for a variance just based on the fact of where this property sits, what the land looks like, and the home that they're building. So here was the existing home.
So
Yes.
this is the plan that they went with. They didn't have any elevations or anything when they started?
That's just the survey itself. So they didn't realize they needed an elevation. They didn't know that there was a second story setback. They were just building to the height that was allowable within the zone.
Elevations were provided
They were,
in the building permit application.
but they
they
just didn't
weren't-
realize the line was there.
They were not labeled with heights. And then we had asked for clarification and the builder said that it was compliant and wouldn't provide additional documentation.
And he just
Yeah.
elected not to.
He or she's allowed to.
So I mean, we
Like if
we
you-
asked that they.
And he didn't provide it, you can't put a halt on it.
So I mean, it's kind of a policy, of what gets done and not. We now do require it, that we get stamped architectural plans, but at that time, we asked for clarification. The builder said, yes, it meets side yard height requirements, and then we
But
moved
if
it
he
along.
says it does and it doesn't, then he goes and it's an as-built, it's his risk.
You're right.
I mean,
Exactly.
Yeah, no, when I,
Yeah, I mean,
I-
that's
it's
how
like-
we.
It's
when
like
I
my
read
fault.
that,
Up here.
attorney, that is a significant point.
Yeah,
That popped out at me that he was asked by the town to provide details. And he represented to the town that a professional that they were compliant. And the town requested backup and they weren't given, kind of pisses me off.
Right.
As representing the town.
And
And that is a big negative here. So
I understand. I
just let
understand
you
that.
I mean, they were warned.
They were warned.
It isn't like we
You know,
built it and it happened. Like we saw some with the pool where the guy didn't get the permit and the deck.
It's
the deck comes from
disrespectful.
They were warned with the pool, just to be clear, if they're
Okay.
gonna bring up the pool, they were warned.
So this is disrespectful for the town. And why shouldn't the town just tell them to tear it down?
And he's got insurance for that. What's the issue?
I
Right.
believe that the issue is they were still working off that survey that wasn't showing that line, which is why they thought it was.
David, he was
That's-
specifically asked, that the memo states, and I read it 4 times, that he was asked if he was in compliance. He represented to the town, he was an official, that he was in compliance. He committed something, whatever there. He failed to give backup because that would have helped him. So that is a significant moral violation, and it could be I don't know, I'm not a lawyer, but I'm surrounded by lawyers, legal violation. He misrepresented something to the town, period. So, I mean, unless there's a defense for misrepresenting something to the town, and now someone gets to misrepresent something to the town and says they're in compliant, he comes after the fact and begs for forgiveness? Like, what's the hardship?
Well,
You
can
know,
I-
I mean, it's just not what the town is about. If it's just, what's the purpose of having a zoning board and paying Sarah for her professionalism? Like, why am I paying her salary as a taxpayer if she doesn't have the right to request something?
I think it's kind of nice of Sarah to put them on notice, like you might want to get an elevation plan.
It's
I mean,
just
she didn't have to do
disrespect.
that.
And now they come here after the fact, wanting to try to, get relief.
Can we make a point of clarification? It was the contractor who misrepresented
Correct.
to Sarah.
That's his hired
Yes, but
representative, so
if
the
the
contractor has
applicant-
insurance.
Applicant is the homeowner.
It doesn't.
It
Yeah,
is
but the
very
applicant-
possible they were as in denial of what was represented to Sarah as we
Ignorance
think
is
has
not
been.
I'm not a lawyer, you are, but ignorance is not an excuse of not abiding by the law.
just saying,
You're
maybe-
the homeowner, you're responsible, and his or
Okay,
her
so-
hired
but
professional
maybe we
lied to
review
the
this,
town. That
giving the benefit
professional
of the
needs
doubt
to
to
pay
the
the
applicant.
consequence.
Well, I don't think that this analysis is necessary because either way, as Attorney Rucci said, we're gonna look at this as if they're proposing this in front of us, just the way we do every other application. We're not gonna give, and we're not gonna count points for or against it because it's already on the ground. And I think that's what he was about to do, is we're gonna look at it and say, if they came to us now and hadn't done the construction first, doesn't meet these requirements that we just went through in the last application for variance.
But then I agree, and but then everyone would. do
No,
this.
because then there's a risk on the builder that if we say it doesn't meet it, then the homeowner is gonna say, well, you have to straighten this out. You need
Right, and
to.
there's obviously been cases like that before where people have gone out and done things against
Yes,
us.
David, and
Yeah.
you presented them, but it was.
Well, I don't
something
always
where they
present them.
weren't- Well, it wasn't
Not always
something
there for
that
that.
they were explicitly told they were in violation. If it was like an oversight of something and like they weren't told by the town. Here, the town official told their hired professional that they were, they thought they were in violation. They represented they weren't. Like
Right.
we never faced that case. We faced cases where, there was 5 feet over, the coping was thought about, the line instead of the inside of the pool. I mean, those are kind of like things you could understand, but when a town official tells someone you're not in compliant, and then the guy represents that he is in compliant.
And then he goes forward and builds.
And he bills, I mean, like,
It's like,
shame on him. I hope he
Unbelievable.
has insurance.
No,
but at the
I
end of the
understand.
day, that doesn't affect.
Yeah, I understand.
That's might be like an emotional issue,
Well,
but from a legal analysis, I think it's important that we like reset this to like
Yes.
ground zero.
Okay,
If they came to us with this application and nothing was already on the ground, this wasn't done yet, would we approve the variance?
Okay.
That's
No,
how we
yeah.
always look at these. If they want to proceed and tell Sarah we're all set, whatever, well, then that risk is on them that we might not grant the variance. And then if this happens other times before, we say, well, you gotta fix it. It wouldn't be the first time you said that. and I'm
okay,
sure it won't be
okay.
last.
I'll-
So that's the risk on the builder. I mean, that's, I guess,
I will
that's
represent that. I will look at it.
I
from
mean,
that
I don't think,
frame.
no
Mr.
one,
Chairman, to your point, just a couple of questions in terms of the power of this body. We've got, in terms of granting variances, there can be conditions associated with them. Is that correct?
I guess so, yes.
Okay.
So I mean, it would depend on what the condition is, but, in the past, we've always looked at these, and I think this is a standard that I want to keep as a board. I think it's a standard in the law. We can scold the developer or the builder or the property owner all they want. But at the end of the day, we're asking whether or not we would grant this variance. And there's times I can think of where, we told the person, no, this isn't reasonable. You gotta move the generator, you gotta move the pool, you gotta do this, you gotta do that. There's other times where we said, no, if you came in here today, we think this would be, something we'd grant the variance on. So that's that's the prerogative here, and if we, then the onus is on the property owner, and I guess, the reason why builders, I think, would typically have responded to Sarah's request, and would be that they don't want to get to the place they're in now, because they're at a place where if we say no, they're gonna have to somehow either, be working for free to make this thing fit in, or they're gonna be making insurance, and then have to be doing something that is some cost to them. So I don't think that scolding them is helpful, and I don't think that this is the first or the last time we'll see this. It is unique to Dearborn, but
Duly
The
noted.
the applicant has made some efforts to try to find
Yeah, let-
other solutions before even coming here.
Yeah,
too.
maybe I should just continue on and we
yeah,
can
no, I
discuss
get
this
it.
after.
So I think we're just gonna proceed as if this is
Yeah.
like an application square one.
Of course,
Background doesn't matter a lot from our analysis.
I understand.
Going forward here.
Okay.
So just sitting back, so we're in the half acre zone. We're on a shared driveway. The property, this is what the property looked like before. You saw the front of the house earlier. This is the rear of the house. It's about a story and a half. And what the applicant did was they built over this spot, right over this roof line here. So they essentially built up. Okay. So if you look at this property here, we're talking about this side of the property, which is the southern side of the property. You can see that you have quite a drop off. It goes from it's about a 14-foot drop off from that point and other. So it would have been difficult to build anything obviously into this area if you wanted to, meaning the single story, which you could have built a little bit further out. Okay. But instead they went up.
Attorney Rucci, if you're
Yeah.
facing the house, is that, I can't picture some mine. Is that on the
So-
left side, the common driver's side? or is it on the-
Yes. Yeah. So here's your driveway right here in the front.
Okay,
Okay, so this is so here's the access way coming up, and then you pull into this driveway here. So here's sort of the front.
Okay.
Here's the drop off. There's the second story. So the area of the second story that's actually in this second story setback is about 12 square feet. It's this tiny little red triangle right here that actually violates
is that on
3.5.
these plans?
Yes.
Page 11.
Yes.
Page 11. Yeah. Okay. So that's the area that, encroaches on it. And if you remember, and I'm pretty sure this board is very familiar with this particular regulation, but this is the regulation that came into effect when they were building all those houses up and down South Avenue and on those little streets, and they were putting them like straight up, and they were like, basically covering the house. You couldn't even see the sun anymore. So they came up with this rule in the smaller zones, in the half acre and the A and the B, where you basically, your second story setback has to be set in further, right? And that was because of loom. They didn't want it looming over the house next to them. And the reason I wanted to bring that up, because in this particular case, there's like zero danger of that happening. And you'll see that when you look at it. So the intent of the rule, and I know you went through that in the prior application, is, this is perfectly within the intent of the rule. It's not violating that portion of the rule at all with respect to the reason for the rule. The reason for the rule was to stop loom. You will see from the application that is not a concern here. So this is just trying to show you kind of what it was supposed to be. You have an allowable side yard height of 20. It's actually 27 feet in that 12-foot area, okay? You have a total height that you're allowed for of 35 feet, 25 feet, and it's 31.8, those 12 square feet, okay? In that area for the second story setback. This is essentially what it looks like, okay? It attaches to they just basically took the part that they had in here and they added this area to the top here, and it just lines up pretty much with the roof line that they had earlier.
Why can't they tilt the roof back?
I'm sorry?
If you go back to that picture there,
This one?
where there's a vent on the top, that's the area that's violates the height, or is it the?
I think it's on the other side.
The others.
It's on the other side.
So it's not the,
It's on the corner right here. Okay, so if you look at, it's gonna be like in here.
No, I think.
No,
it's
to
the
this
side
side?
of the deck.
overlooking the deck, isn't it?
Let me see. Hold on, sorry. Yes, overlooking the deck, sorry, right here. So here's your deck. Whoops. Here's the deck. So it's like right here. Sorry. In this area here. So, I mean,
And if they change the pitch of the roof, could they address it through changing the pitch of the roof?
I don't know the answer to that. I can ask the architect who's here. I was gonna go through the other items. If I finish this, maybe we can
No,
go
let
back
me
to that
finish
question.
I was-
Okay. So as you can see, this is basically the area that you would be looking at. This is where the loom would be, in other words. This is the eastern side of the property. So there's nothing there but woods to a certain extent. There's no neighboring properties that have been, have any, can't even see this particular piece of this house, okay? This is sort of the, this is the edge of the house here. And as you can see, it kind of flows down in this particular area of the property. This is that southern line on the other side of the property, on the other side of the deck. And this is the topography drop off that I talked about earlier on the particular piece of property that kind of comes down here. That's your 14 feet from the edge to basically where that stone wall is. And this is just another look at it from the front of the property. And this is looking backwards. So here's your deck here. And then this is the screening that you have on sort of the northeast view of the property. And this is just an area of the property that has a whole bunch of mechanicals in there right now, which wouldn't have been a really conducive place to have built any sort of addition. This is also the area, they have a little yard area over here. Going to the hardships on the property, you know, we have this sharp drop off of the property that we talked about, that I showed you a little bit earlier, about 14 feet. It's in a regular shaped lot. If you go back to the beginning of the paragraph, you'll see that it's sort of that pie shaped lot. And we're talking about the interior layout and architecture of the house and renovation. The best place to have done it was sort of in the area that it was in, where that particular the single and a half story was. That's really the best place that they should have put the addition, based on the fact they had mechanicals on one end, it topography issues on the other end. It sits back against the back of the property. In the front, you saw that big drop off just coming up the particular driveway itself. Right in here. So this is, you know, where else would you have sort of done that particular type of construction? They did make some efforts to correct this problem when it came to the homeowners' attention. They tried to land swap with the property next door to try to get those extra like 5 or 6 feet. That did not go well. We actually met out with the town planner and with the assistant town planner to talk about maybe raising the grade, because the way like you measure grade, like maybe there was a way we could put some dirt in here and just raise it a little bit so that when you took the measurements from each side, it would just have taken it out of it. But you would have had to bring in 7 feet of fill, like around the entire house, to bring the grade up. You couldn't just do it in that one spot in order to kind of make that work. And the applicant was willing to, you know, take on that expense to do that work. I mean, obviously not that much work, but to try and to raise the grade to get it to a point where you wouldn't have that 12-foot encroachment.
And just to be clear, bringing in that much fill and changing the grade that much is a violation of the zoning regulation, so it's not allowed.
Could they do with a special permit?
No, you'd need a variance.
You need a variance. Yeah.
So that wasn't
How much
really,
fill is it?
it's going to be about 7 feet of fill for a width of 10 feet around the entire.
How many yards? Like, where does this?
Well, so it's not about the cubic yards of bringing it in, it's how much you can change the grade on a property. And yeah, do you know the exact height that you're allowed to off the top of your head?
Well, it's more the slopes.
The
You only
slope,
get a
okay.
3-to-1
Okay.
pitch, or you can only be a maximum of 4 feet with retaining walls, plus how close you could be to the property line with retaining walls.
And they changed the water flow.
Yeah.
And then you get into the wetlands.
It's all
It's a whole
wetlands around
different-
that house anyways.
Yeah, you can see there's some wetlands in this corner here. And then we have this steep drop off on the other side of the property. And it's really kind of a steep drop off just when you come up the driveway itself of the property. This is the existing house again. Would you like the architect to?
Well, I'd be interested in what was there before that, square foot bedrooms, bathrooms, like why? I mean, it's a unique lot, but I think the question is why is this, necessary? Like, why wasn't the house, adequate before this? Like, do you have?
Well, I
you
can
to
certainly have the
bedrooms? Was it
architect.
undersized? Like, what was the fact pattern that necessitated this?
Well, let me have the architect, Carlos, you want to come up and just.
Good evening.
Oh, just introduce yourself.
I am Carlos Diaz. I'm the architect. I'm the one who designed this reduction.
Good evening, Rich Carey too. Can you start with like what was there before, like approximate bedrooms, bathrooms and
Square feet.
square feet? Do you have all of that?
Yeah, it's all in the existing conditions right there. It's the client just wanted to add another bedroom.
Can you repeat? I'm
I
sorry.
couldn't hear you.
The client just wanted to add another bedroom to the
The
house.
bedroom?
Another bedroom.
Yeah, so the only viable solution was to go up on the existing footprint.
And how many bedrooms were there is? The original bedrooms, number of bedrooms,
I believe three.
three bedrooms.
yeah.
Okay.
Yeah.
Did they add a bedroom or also a bath? Like, did they need to add baths or just a bedroom?
Just a bedroom,
So above that space is just one bedroom.
bedroom.
That's all that's in the space.
Well, there's two bedrooms right now, but one was added to the existing, and there used to be a bathroom there, which we just redid it basically in another area of the house. I mean, in that area.
I can give you guys.
They've
more-
just introduced
Oh,
us.
sorry. Gavin Parker, I'm the homeowner. So it's a 3-bedroom house currently, and we were having our third child, so we wanted a extra bedroom for the baby that was coming. There's 3 bathrooms, and in the construction, we basically moved one of the bathrooms that existed and put it into part of the addition. So it's still 3 bathrooms total in the house.
So we just moved the location of the bathroom.
Mhm.
So the new addition was, you were able to move the bath into it, plus an additional bedroom.
Correct, yeah.
Where on these plans is the new addition? Like, I have the demo plan, the existing and demo first floor plan and the second floor plan.
Page 26.
Is there a new bed on the master bedroom?
The back right corner is the new bedroom.
Okay. So it's 4 bedrooms on that floor, or is the master bedroom on the first floor?
It's now 4 bedrooms on that floor. Correct. On the second floor,
And where's the first floor plans?
above it.
Right above it on page 26.
But how is the first floor plan smaller than the second floor plan? Oh. So what's on this plan that's missing? Like, what's on the front of it?
Just the entranceway
That's the,
and living
porch.
area.
Sunroom.
That sunroom porch, which is like your page 1 or 2 in your packet.
So is it now a 5-bedroom house with a 1 bedroom on the first floor and then
Yeah,
4 on
actually,
the second floor?
The bedroom that is labeled bedroom in the first floor is actually the living room. It was just a
It's a fireplace and it's connected to the deck.
It's actually a living room.
Yeah,
So it's 4 bedrooms now.
Correct.
yes.
So is there a closet in the living room or is it a bedroom?
No, the first floor is a living room, it's not a
It's a living
bedroom.
room.
No, if it was a bedroom, we would have septic and we'd have to do a whole bunch of other. Is there septic? Is that septic or sewer?
sewer, down sewer.
That's town sewer. I guess you could have technically done another bedroom. But no, the second floor is their living space, their bedroom space.
So on page 26, the part that was actually added
is what is not listed as bedroom existing, but it's the bedroom and the new bathroom towards the back of that lower left-hand portion image, right, for second floor plan.
Correct. It goes
Okay.
laundry closet, bathroom, bedroom. That is.
And it
the-
just basically moved the bathroom from.
Correct. Yeah, the bathroom just moved backwards.
What's
towards
the
back.
dimensions of these bedrooms? This plan is so small. Like this front bedroom, Attorney Rucci, what are its sizes?
Of the what?
Can't
I'm
read
sorry.
that. If you went through these bedrooms, the first, like you're facing the front,
Mm-hmm.
it says bedroom existing, what's the size on that?
You know what size of the bedrooms are?
They're about 11 by 12.
And the one behind it, in the middle of the house?
This one? This one that I'm pointing to?
Yes.
Yeah, they're about the same size, maybe like 10 by 11.
And the one in back?
The one in back is 10 feet, 2¼ inches by 9 feet.
I mean, they're certainly not building anything grandiose here. A 10 by 9 bedroom is,
Pretty small.
it's pretty small.
The triangle wedge that comes out to 12 square feet, do you have the actual dimensions of length with,
Oh,
it's just easier for me to visualize,
It
like,
goes from one
the
corner
portion?
0 to about 11 feet. No, the total is about almost 11 feet, square feet.
no, but is it like on one length size? Is it like, 6 feet by like
One length is.
2 feet? Or I'm just trying to visualize.
Take the
calculation.
triangle, this side is 3 feet, and this is about, I believe, like 10 or, and then it goes to 0.
yeah, so if it's 12.5 feet, then it's gonna be 3 feet
By 4
by
feet about.
4 feet roughly. Yeah.
So, I mean, it's.
Like, no, 3 feet by
It-
8 feet because it's
it's
a
not-
triangle.
I mean, it's
Right,
obviously
yeah.
not a lot
3
of
by
square
8 about.
footage, but in a room size that hasn't been added on, it would have made a significant impact to
No,
take
because-
this little wedge away.
Well, I think the question I have is, I had before is, if the roof pitch is reduced, wouldn't that address this issue, the mid-roof height issue?
Can we go back to the outdoor photo as we're doing this?
Which one,
Um,
Ms. Schneider?
The one that shows the roof over the addition,
No, the new, that.
the new.
There,
Yeah,
thank you.
if you reduce that pitch, wouldn't it solve your issue? I mean, because that's, reducing the pitch isn't gonna affect the bedroom.
It would be the room in that area there, that corner would be unusable if we had a. Well,
Because
Why?
the ceiling is over the window of the room.
yeah,
Be like,
So like if we made a flat roof, even with the window on top, the room would be unusable.
Yeah, it's over the bathtub.
So inside the,
It's like,
so it's not like a flat, so it's not a flat ceiling inside, it's a ceiling like, it follows the roof, like a dormer. Vaulted.
no, inside is a flat roof.
Okay, so
But could you say, yeah, say if you cut it off at the gutter, would it change the height of the room?
To comply with.
It would?
Yeah, if you look at the survey with the red outline,
It
it
says
still
the part.
includes that farm.
Huh?
That survey there includes where that gutter is saying it's in violation.
Yeah, but
Let that all the way out to that peak where it's.
right, but it's.
But it'd be less. It would reduce it.
It would- like in theory, can you go back to that, I'm sorry, the picture again, the new, yeah, in theory, can you, well, not in theory, can you make a flat roof like right above the window? I mean, you're getting rid of the attic, because that vent, I assume, is where an attic is.
Yeah.
So can you slice it basically and make it a flat roof?
Where is 25 feet? 25 feet would be compliance.
It's mid-roof is 25 feet, right?
No.
Oh. But the area that's out of compliance.
7 feet.
So basically 7 feet over.
Okay. Yes.
But which is at that top point of the roof? Yeah, that would need to be.
you'd have to bring the whole thing down.
Yeah, the whole thing.
The
You
top
wouldn't, you
roof-
wouldn't be able to just cut off something right here and make a flat roof. You'd have to bring this whole, I believe you'd have to bring this whole ridge down.
Right,
Yeah.
yeah, it'd be a flat roof.
Yeah.
Or a more gradual slope, and you'd have less attic space.
You would have to have a flat right there.
Yeah, flat roof.
Like
Okay,
that.
but we're not gonna tell someone they have to have a flat roof.
No,
I
I'm
think
we're
that's
just,
They're gonna have, what are they gonna do? I was a kid, I used to have to shovel a flat roof. That's terrible.
well, you don't have to shovel.
Yeah, I
You
mean,
do, yeah, because you get ice and snow on. You have to shovel it. It's flat.
there mechanicals in the attic?
is there mechanicals in the attic?
Yes, we have a air handler.
So they can't hear you on.
Yeah, but
Yeah, you have to come up here to speak and you have to say who you are.
is he allowed to sit there?
Here. Thank you.
Yeah, you can,
Sit, that's fine.
take a seat,
Take a seat.
wherever you want.
Yes, so there is a mechanical, but it's on the existing house of the
It's on
house.
the other side.
Yes, so we just bring the existing ducts
Yeah,
to the new bedrooms.
yeah. So
There's
probably-
nothing about the new rooms, just ducts.
But you.
What about ductwork?
Yeah, just the new ductwork.
Ductwork.
Yes, that's
You would
it.
have to bring the peak of that roof down 7 feet, you're saying?
In the midpoint.
It's a
It would have to be a
roof.
flat roof.
Does that be a flat?
That still wouldn't work, because you have to meet midpoint height with your flat roof, because there is no midpoint.
Yeah, but it'd be
Yeah,
less.
no, it's the
But then
same.
it'd be more than 7 feet probably.
Yeah, it'd be the same. That's the crazy part about the flat roofs, is it doesn't have a midpoint. It's actually, we just had this issue over on not Fort, Richmond Hill, where we were talking about this. It actually, this way is actually easier, believe it or not, from a midpoint perspective than doing a flat roof, because the flat roof has no midpoint to it, so you're actually held to it's actually lower.
I am the.
Yeah,
You're saying there would be an increased variance with the flat roof?
probably,
Yeah.
yeah.
They'd have to effectively just cut a random shape.
It would
of
at
this
least
roof.
be a trade-off. It wouldn't be an improvement.
Okay.
Yeah.
Yeah, I mean, but I would just go, I would also go back to, the fact that in this particular area, this is what it looks like.
Yeah, I know, Dave.
But you're relying on what the neighbor's doing, and you can't prohibit the neighbor from ever developing, to make yours conforming. That's the neighbor's property you're looking
But
at.
what we want to do is, we want to imagine this isn't built yet, and we're looking at these plans.
Right.
As though it hasn't been built yet,
We
and
allow.
we're saying, wait a minute, this is out of compliance. Only the minimum should happen. Could you adjust this so you would not have that 12 square feet?
And we couldn't say,
That's how we
and we're
would-
not saying you're making a bedroom any smaller, 9 feet by 10.
No,
feet, tiny bedroom.
No, it's whether we could say, do you need the bedroom?
I mean, reducing the pitch, it's still gonna be non-conforming,
no.
you know, it might go 12 feet to 6
Agreed.
square feet.
The
or
real
whatever.
answer, the real question here, in my opinion, again, Rich Caratu, is that if it was presented with the plans, we would sit back and say it's an existing 3-bedroom house. Is it a hardship that he doesn't have 4 bedrooms? And congratulations on a new baby, that's
Thank you.
great. I mean, I don't want to get too personal with this stuff, but, is that, I mean, from the class we
But
all took.
we're not
this
allowed
would
to
be-
consider personal.
No, I know,
Yeah,
I'm just
it's not a
congratulating
personal
you.
hardship.
I'm just saying, you can't,
Of course.
what we're
We
saying.
want you to have many more kids in our town. From the class we all took, they made it very difficult for a hardship. I mean, like you have a 3-bedroom house in a half an acre lot in New Canaan, that's sort of normal. Just, from what I read and from, I remember.
Seems that way to
class.
me, I mean, I live in a 3-bedroom.
I mean,
There's a lot of
agree.
3-bedrooms in town, I don't think it's
But what
unusual.
we're asking for, listen, we used a part, one of my points would be that we used a part of the property that was already built on, okay, in order to expand the home. We didn't go any closer to one side to bring in more fill because of the topography. We didn't go to the other sides where we would have had to move all the mechanicals to get there. We couldn't get somewhere else because of the wetlands. Okay, we did the best, they did the best they could with the spot that they had instead of increasing anything anywhere
Okay,
else.
right,
So-
David.
David, you understand that, but the question
Is that a hard?
Is that a hard, is it reasonably necessary use of their house to add a 4th bedroom?
Yeah, and I would say that it is. I think that
Why?
everyone should
Why?
have the ability to improve their house. Everyone who comes into this, into this board right here, or the P and Z board, is always trying to improve their property, for the most part. I mean,
Well, within the law.
no, well, yes, but I'm just saying, that's just
Well, P and Z is
right? That's
different. P and Z is doing things that are allowed, you just need a special permit. Here, we're doing things that are prohibited.
Not always, though. I mean, there's things that you go into P and Z for where you're trying to improve your property and you're asking for relief of a certain regulation, or you're asking, like, we've had to go there before. There's certain special permit applications, like the 4:1 ratio. We've had to go in there for other things that you ask for more grading, you ask for more things to be done.
I'm saying those are all allowable things.
I think the request in front of us is very consistent with several we have granted before. It is a pretty small scale with respect to what they were trying to achieve. We've allowed bigger setback variances, we've allowed height variances. It is 12 square feet of impact. They are not asking for a coverage variance, so to try to actually build into the space, it's difficult. There is
Then you don't build.
topography issues.
And you don't build, I mean, you pay the price for a 3-bedroom house, that it was zoned for a 3-bedroom
I think
size house,
we're
and now you can.
not looking
a
at what we've
4-bedroom
done in the
house.
past, and I think this is a pretty small
Are the
request.
ceilings in there like
And
they're
there's
usually
actual
high? Are they like
hardships.
regular height ceiling? This is a
Yeah.
regular. I mean, the house in the neighborhood is not an overly large house.
No, agreed.
I mean, I think. we all-
Agreed, I walk
It's
around.
a small house in the
No, it's a
neighborhood.
good looking.
It's not like this doesn't fit in with the neighborhood.
No,
It's not like they're putting, a 6-bedroom house in where every other house is 4 bedrooms.
No,
I
I
mean,
agree.
it's not like they're doing anything. excessive.
of reason, yeah.
I mean, they're not asking for 12 square feet of coverage. They're not asking for,
And I think also.
I didn't be interested in chatting now, honest comment, but.
Do you want to go first? No one let you speak yet.
Yeah.
Just make sure your mic's on.
Yeah, and so following up with what Jessica said, I do get the height issue in the back corner of the site. When I drove in there, looked around, kind of fully screened, so I appreciate that there's obviously no neighbors here for or against to either offer any comment for the record.
There's no one on Zoom either.
Okay. Obviously letters from neighbors, definitely is good to hear from. So, my thoughts are I'm generally in favor of granting the variance, but I am taking this into consideration because, I mean, as Rich said to start off with, the disrespect is
Well,
real
yeah,
to
but we gotta
staff
separate,
and boards.
despite as
So-
much as I'm upset about it, that you gotta separate.
Yeah, I know, I know.
I agree with that.
Luke's resetting us to the,
I'm
I
like-
mean, I think it has to be said, I think it's really egregious here, that the homeowner and the builder and the architect and all these people would ignore the town like this, but that's not,
Can I say something?
that's not our decision.
Sure.
Yes.
I gave the drawings to the client, obviously, when they were done. And they were given to the builder, who went and filed for a permit. I didn't know he was gonna file for a permit right away. Then, when the issue came up from zoning, I was never informed of that. I would have looked into it and say, let me see what I can do, or tell the clients, you cannot do it. I was only informed when the building was already up.
Yeah, well, that's not.
Have you done other projects here in New Canaan?
Yes.
Are you familiar with the setbacks and the height restrictions associated?
Yes, but not this particular one, and especially when the original survey didn't show that setback. It showed all the other setbacks, and it didn't show any average grade or anything.
But Mr. Parker, didn't the builder come to you and say like, we have a problem? Or was this like you were blindsided by this?
Yeah, I found out in January, 4 or 5 months after the project was already complete. So I had no idea that there was any issue. As far as from my perspective, the permit was approved and we built, everything was good. And then, 4 months after completion was when I first heard about it.
Yeah, these are the original plans that were put in. You can see that the architect didn't have it on his survey to begin with when he put the plans together for the building permit.
Look at, outside the way Jessica said,
I'm sorry.
I'd go the way Jessica said. I think it's a reasonable use. I mean, in that neighborhood, I think, looking at the houses around it are all much bigger than it. It's definitely the hardship as to the topography and things like that. 12 square feet is so small. We have done, height variance. It's not even it's not even footprint. I've seen that this isn't the first time someone's come here with this problem after construction with the roof heights and this and that, and the roof heights aren't, I've seen us grant a variance on that at least once previously with the roof heights being off because this calculation off here. What's unique is that they were warned about it, but again, we can't, I'm not evaluating that in my analysis. I'm thinking if they came here and they said, we want to add a bedroom, where I sit here, it's kind of like a 1-car garage or 2-car garage. You've generally said, having a 2-car garage, and depending on the neighborhood and factors like that. But as long as you're within your minimal size, that's, within the scope of what people expect. 4 bedrooms, if these were large bedrooms, let's say we made one smaller or this and that. If they could cut the roof or change the roof, I'd say, well, change the pitch of the roof. It doesn't matter. It's not my issue, but that won't solve it. They can't make the ceiling. If they had 8-foot, 9-foot ceilings in the bedroom, I'd say cut the wall shorter to it. I mean, I don't think there's anything they can do practically short of removing this bedroom, because if you make it a foot shorter, it's an 8-foot by 10-foot bedroom. I don't even know if that's like a legit bedroom at
And
that
it
point.
wouldn't even necessarily solve the full problem.
Yeah,
Right, right.
Is there a quick question? It just, for going forward, is it the policy now of
We need
also
stamp-
notifying the homeowner when there's an issue like
So
this?
that is a constant challenge that not just planning and zoning, but all the land use departments struggle with. If a contractor does not, a contractor has to fill out, the form. We ask for phone numbers, email addresses. But typically, I'm not saying that this was done, I'm not sure, but we've had cases where contractors put bogus phone numbers, bogus emails, just to make sure that they're filling in the required item. And, a lot of times homeowners also don't want to be contacted by the town, they're paying someone to do the work. So we do require it. Unfortunately, things still slip through the cracks.
So in this instance, there are, your only communications were with the builder?
Correct, through
not with
the,
The architect, not with the owner.
correct. So with the architect, for example, if they're not the ones submitting the permit application, it's up to the applicant, whoever that is, to provide us with that information or, make them a guest on the permit. If they don't do that, we can't require
You
it.
know what, that's probably the solution. You should make them on OpenGov, put down the email of the other person, so every time something gets filed or there's communication, it has to go to the owner.
Yeah.
But they are also authorized agents through.
Yeah, so-
If the homeowner's authorizing, the homeowner's risk if they authorize them is their.
I'm just saying to
Yeah.
solve that issue as to whether or not the homeowner's actually knowing that things are going
Right, or
back.
maybe the homeowner wants to be not,
Yeah,
celebrity.
Yeah.
Yeah, like it's neither here.
So
I mean, if it's footprint, the roof height is. On the back of the house, with the topography like this, with the wetland like that, with no way to add the fill and apply with this 4-foot retaining wall setback type thing.
It comes down to whether a 4th bedroom was needed.
I know.
It's like there's a-
That's the way I look at it too.
Yeah, I mean, if a 4th bedroom is sort of considered not having one as a hardship, then it's a slam dunk, right? It's whether you would have approved a 4th bedroom. You're looking at it, say it's a 3-bedroom house, and that's sort of what the homeowner.
Yeah, that's what this case here, what site says.
Well, that's
So in the typical case of a property owner with a 3-bedroom home who seeks an addition with a setback. Because there are wetlands on the other side, no variance can be granted since the 3-bedroom home is still of economic
We
value.
went
as
through
is.
that in the seminar we took, that we were required.
Like, how are we supposed to get past that?
Yeah, that's my only issue here.
Are there
I
any
feel-
other non-conformities on the property right now?
But
I
you
don't
can like
believe so.
ameliorate rate? Nothing, Dave?
No. But I also think, the whole intent of this rule is for Lumen. And this is doing nothing. The rule itself is put in just for that reason. It wasn't put in for any other reason, that's second story, right? Except for to make sure that you weren't putting your property up against someone else's
I know,
property and it was Lumen.
We've seen this so many times.
And I think that's important to note though in this situation,
I
because there
think-
is nothing around this property.
I do believe it does,
There's
it
nothing
doesn't,
around
it
it.
does not, this 12 square feet does not frustrate purpose of that regulation. It really does. At least the way I see it, because it's dealing with
there's
the loop.
there's no de minimis.
Yeah, but there's no diminished, it's like, no harm, no foul. It's the rule basically. It's still, the rule is what it is. Like, we had a case where he told a guy he had to make his wall he had to get rid of, and no one can even see his wall because it's behind a stockade fence.
I think that was my client.
Figures.
Well, you know how I voted on that, it was 4-1.
You know, and I also think, but I also think like, just getting back to the whole point about this 3-bedroom versus 4-bedroom, I also think that we should be encouraging people to stay in their homes and live in their homes.
No argument.
And try and, like,
But
he loves this neighborhood, he wants to stay here.
No argument. I mean, I agree. It's commendable. We want him to stay in with him and his wife or whomever in this house and develop in our community. We don't want him to move to Darien. But the question is, you know, it's just the law. Like, you know, we've been taught, when we took our class that we were required to take, the attorney went through this exact example. And he said it wasn't a hardship. So I feel so bad. I mean, I don't know what to do.
The materials, yeah.
David, what coverage remains on the property? What buildable coverage?
Existing coverage is 1645, allowable 2614.
They're really well under coverage.
Is this a historic house or anything?
No, it was built in 84. Well, somewhere after 84, it was divided in 84.
Or just a question, are we allowed to ask the builder his view of what happened, or that's?
Doesn't matter.
Doesn't matter,
Doesn't
right?
matter.
I just wanted to bring that up to there.
Okay.
Okay.
Beats everywhere.
And I mean, I'm still somewhat, what I'd like to
I'm-
understand is this house currently in violation of the zoning laws of the town of New Canaan?
Yes.
Yes, that's why they're,
That's why.
that's why they are here.
So I want to know what enforcement is being taken based on a violation.
Nothing. Theoretically, it's like a $50 a day fine or $25 a day fine. We've never charged
So-
before. The real thing is that they can't get a CO till this is fixed. So the
Well,
house, they
to
can't
me,
sell
the
it, they can't
point is-
refinance it, they can't anything.
That's great, and there should be, but when you say we haven't enforced it before, maybe if we enforced it, stuff like this wouldn't happen again.
So we do enforce the zoning regulations. We have a process that's mandated by state statute. We've followed that process. It starts by issuing the notice of violation and a corrective action order. In cases like this, where it's going to take time to come up with a corrective action, we provide more leeway as long as the homeowners or contractors are compliant and working with us. So in cases where we get ignored, you have 10 days, and then we start issuing $150 a day fines. These homeowners have been very responsive from the moment they received the notice of violation. They've been working with us. We had to give them time to do the land swap exercise, had to give them time to do the grading exercise. Every time that those things failed, they moved forward. We met with them. They expressed the desire to attempt a variance. So we agreed to not take enforcement action against them while they were in the variance process, because it would, it doesn't create a positive relationship between us and the public if we go and find someone when they're actively trying to solve an issue. So
Town ever charged $150 a day?
yes, we have, earlier this year, we collected a $70,000 fine for a violation that went on for about 3 years. So we do it when people are not compliant, but if people are complying, we like to work with them to give them time to come up with a solution. But we have no qualms against issuing fines.
So you're saying
do it all the
in
time.
this case, though, the
did not.
applicant has been cooperative from the
Correct.
time they became aware.
Correct.
Kind of like for all of us lawyers, the cure periods that get extended when they can't foreseeably be completed in 30 days, but they're working in due diligence to try to find out.
I've been calmer, but I feel Richard's pain.
I mean, I'm sympathetic and I'm torn, I really am.
I'd like to grant that.
Yeah.
The question is, can we? I mean, well, do you want to continue the hearing and think of something? Come back?
I feel like we do have a hardship, and I feel like we are asking for something that's reasonable within the regulations, and we're not doing anything that's against the intent and purpose of that particular regulation. I mean, the town planner memo itself said they would have supported this variance request had it come before this commission prior to, the action that was taken.
That happens all the time, but we don't hold consistent with that.
Well, I'm just saying that our positions are the same.
How many square feet was the house before?
Oh, it might be on, your page, 3. No, Page. It's right after existing survey, page 6. Well, it didn't change because all we did was go up 1646.
No, I'm not saying footprint, I'm saying square feet, like how livable space.
Well, I mean, what did you add?
We added about
800.
800 square feet?
Yeah, that's what I
You
calculated.
added 800 square feet? They couldn't have. Yeah.
Maybe 5?
Well, I'm counting the attic, but I'm counting the attic.
The room was like, oh my.
Yeah.
I know, but I'm
So-
looking at the attic.
And then the.
Plus the space in front, yeah.
It's the-
A bedroom could be 200 square.
That's not even that good.
Here?
They can be bigger than that, 20 by 20.
Yeah.
Right.
I mean, not mine, I'm just saying, like. Mine, we can only fit it nicer on one side of the bed, so mine decide without the nicer.
Let's see.
Steven's trying to pull up the building permit to see if it's
Oh, that would
noted
be
in the
great.
building permit.
Well, he's doing that. Sarah, can I ask what action do you take against a builder that doesn't reply in a case like this?
So, we have to, if because the violation's on a property, we have to fine, the property owner, and it's up to the property owner to take legal action if they want the contractor to pay that fine or get reimbursed for the payment of the fine, but we don't have the authority to take action against the contractor themselves.
So you don't, flag that builder
So
for not
we've had
replying?
issues with other contractors who were repeat offenders, and we've worked with the town attorney. The town does not have any legal authority
The town
to
can't like prohibit a contract.
flag
from
a
working.
contract or
They
something
have
like that.
licenses.
Yeah.
Yeah, we can only punish homeowners, property owners.
Right, because they're.
Yeah,
Okay.
they've assumed that liability by
Right.
hiring them,
Right.
unfortunately.
Lesson here.
Yes, big one.
Could I understand a little bit better, once again, they focused a little bit, there's no opposition here. So we haven't.
Sorry, just to jump in really quick, it's 230 square feet.
Was
of
added.
But
area
what
was
was the
added.
house, so what's the house now?
So,
1,800 square feet?
so
Yeah.
is it a full 2 stories? So if it's 16,
3,000.
3,000, yeah.
Living,
So
living
more than
space.
This house is 3,000 square feet?
Well, first and second floor,
Wow.
right?
Doesn't look like that. from
Yeah,
the
you're
road.
walking around it.
I'm just saying, the
Yeah.
footprint's 1,600 and you figure it's
Oh.
built
Yeah.
It's 2 full
stories,
stories,
it's
yeah.
gonna
Wow.
be roughly.
Didn't look at
okay, are there portions that aren't?
I got quarter living basement.
There's no basement, really.
Yeah.
Oh, the sunroom also doesn't have a story above it, right?
Oh,
If you look at the elevation.
Plus the foyer is becoming a second story. With a footprint, so.
Yeah.
So under 3,000 feet.
Didn't look at walking around.
Footprint.
The deck may also be included in some of that coverage. if
Yeah.
it's-
So if the applicant had sought a variance initially, there would have been communication with the neighbors. I understand since this happened, efforts were made for a land swap with the neighbor. I'd like to hear a little bit about that.
Do you want me to take it?
Yeah, go ahead.
So yeah, I guess on the point of the neighbors, we sent the letters out, obviously, and I heard directly from all of them that were sent a letter that they were in favor and support of. Were offered to write letters, including, 3 of the abutting neighbors all offered to write letters in support of it. In terms of the lot line revision, it was with the neighbor, I don't know the direction above us. She lives on the house above us. But given that there was mortgages on both properties,
Yeah.
there was
Yeah,
like a
that's
major
all.
issue.
Yeah, that's
Yeah,
enough said.
but she was willing to do it with
Can't
us, like if,
No.
like from a, I
I
guess,
see.
neighborly perspective, yeah.
Yeah.
Yeah, I actually told, when he said that he talked to all his neighbors and all his neighbors said they were right, I was like, well, listen, you can just go in and say that you talked to all your letters, to all your neighbors and, they'll believe you if you just say that you did it. And they said, if people want to complain, they know where to come.
Mhm.
They all get notice letters. They've gotten 2 sets of notice letters on this application because we actually were supposed to be here last month, but then we when we were talking to Stephen and Sarah, they were like, well, let's go look at the fill issue. Maybe you can actually raise it. And so we back the hearing last month but anyway, they've gotten notice letters for 2 months.
Okay, that's why I just wanted to understand the nature of the lack of success on the land swaps, and that's helpful. I was out there today. I mean, the screening, absolutely. I mean, I didn't go up on the property above to look down, and I recognize, we do have full leaf coverage, but some of it was evergreen. It certainly is nowhere close to.
Agreed.
That's the neighbor above. So yeah, there's evergreens there as well.
There's nothing you can do to ameliorate this.
Other than taking down the height of the second story.
When you'd have to remove the second story.
That's what I mean.
Yeah.
You'd have to start again.
No, because you would have to go back to what you had before, because you couldn't have a
That's what I
second story even with a shorter roof. Like you couldn't have could you have?
Right, and that's probably the reason why, Mr. Chairman, that we would have come here to begin with. We would have probably come to this board and said, listen, for us to be able to do this, the way we want to do it above this existing home, we would have to ask for a variance of this secondary setback rule so that we could go up and get the proper, amount of heights and the proper amount of rooms above it. It doesn't make any sense at all to come in front of this board. And we think that in and of itself, that particular rule does provide a hardship to a certain extent as to what you can build on a particular piece of property. And if we were like, all right, forget it, we don't want to build there. We want to go build on the south side, we couldn't do it because of topography. We want to go build on the north side, we couldn't do it because of the mechanicals that are sitting there and the chimney that's happened to be sitting there. You can't build on the front of the property where the driveway happens to be. And the rear of the property is the same issue. So we would have been in front of this board to say, listen, this is really the only place we do it. It's the least intrusive of any of the other spots. We're building above a second story, a story that's already there. So there's gonna be less disturbance to anything else. We're not digging new foundations. We're not taking down trees. We're not dealing anything with the wetlands. This is really the best place to do it. But in order for us to do that, we're gonna have to get a hardship. I'm sorry, we're gonna have to get this tiny little corner.
If the house was square to the back rear property line, you wouldn't have this issue, right?
No, you would not.
See, the house is, because of the topography there, the house is kind of pretty angle because it drops off into a swamp in the front. It's like a cliff on the other side.
Yeah, again, I don't disagree. I just got to get my head around, the hardship is what's a 3-bedroom versus 4-bedroom. The house is a 3-bedroom and it is what it is.
Yeah, that's kind of what
That's
the hard part.
It's probably not a legal reason, but both of my older sons are terrible sleepers, so we were trying
doesn't count.
trying to not have them share a room.
Appreciate it, but
I mean, that's what I can't get.
Attorney
I'm
Lucci, I'm
trying.
concerned you're not gonna have 4 votes.
I have to say that the lot is challenging.
Definitely.
And when you look at where else they could have built, and I hear what you're saying about, do they need a 4th bedroom? And, could you live with a 3rd bedroom? I don't think that the ask is that great. And I have to say, I don't have an issue with granting the variance. I think that, we're not talking about, as Jessica mentioned, they're well under coverage.
Yep.
I think it's reasonable to grant it myself. I'm in favor.
That Sarah wanted me to take the class, I wouldn't know. It's.
And I took the class too.
You did.
I
and
did,
what he
I
said,
did, I did.
This was, but I know, I'm inclined.
We're
to
looking
be
at a slice of a
positive, but
pie.
I'm inclined to be positive also, yes, we are encouraging this type of.
I think it's the type of application that if it comes to us before they're built, we would have actually said, we really appreciate your due diligence in evaluating the challenges in lot, of presenting to us the least ask possible for what you're trying to achieve. And I think that ultimately really is. This was not a big addition. It's a bedroom
Yep.
and a migrated bathroom. It's not even an added bathroom. And so to me, I think based on the challenges of the lot, which they have challenges all around the entire lot, the topography is a significant issue. The fact that they've actually tried to look into other solutions too, those solutions, including the fill, actually almost proves their point, how challenging it would be to build anywhere else in the lot. I think it's one of those ones that if we looked at it, we would have said, based on the issues that run with this particular piece of land, the shape of the lot, the topography of the lot, the wetlands, this is a very reasonable ask.
Are we allowed to say that he has to stay in New Canaan for at least 10 years and get settled? Because remember that one variance we gave on South Avenue? A month later, we gave the variance and he sold the house. Right? That,
It runs to the land.
Yeah.
Definitely
You know,
been
it's
here
just
a
the
long
kids
time.
play football as well. One
Yeah,
defensive
yeah.
end.
All
Football.
right, yeah, no, that's already part of the
they
plan,
go to
so,
New Canaan High School, we don't want this St. Luke's
of
stuff.
course, no, of course. Public school all the way, don't worry.
You feed them well, so they are football players.
Yeah,
That's-
exactly.
Okay, there's no impact on surrounding it. We're in agreement?
Yes,
Anyone thinks?
the
Okay.
neighbors are positive.
There's no one here against it. We'll ask that later, but let's presume no one for or against.
There's no one on
There's
Zoom,
no.
like actually no one on Zoom.
Is the change in harmony with the general purpose and intent of the regulations? I think so, because as Attorney Rucci said, is to present loom, and in this unique characteristic here, I don't see a loom factor, but not loom.
Yeah.
Look at plan of conservation development, this is consistent with it, this is not doing anything inconsistent. Does it adversely affect public health, safety, convenience, or welfare? No, no effect there, for or against. I mean, I think it's consistent with the intent of the zoning, I think it's consistent with the neighborhood, I think it's very difficult, because I struggle with, is the 4-bedroom necessary, kind of like is the 2-car garage necessary? I think, and if you look at that neighborhood, we don't have statistics on houses in that neighborhood, what's 4-bedroom versus 3-bedroom versus 1-bedroom.
Yeah.
I mean,
We could pull that from the
There are
field part.
sizable houses.
Yeah.
but yeah, that's what I'm saying, that's what I'm saying, that's a
This is
size,
modest house.
that's what I'm saying, like, if you pull up.
That's right. This is,
That's,
this,
that's what
I don't wanna.
The one
No,
behind it.
that's-
Yeah.
Yeah,
That's what I'm saying, this is very modest compared to
Not
the
that
ones
nice,
around it.
Yeah.
It's certainly not
To say
inconsistent
the
with the
least.
neighborhood. It's
Um,
not visible to anyone except potentially the person behind it who has not had a comment.
I mean, I also hang my hat on, I won't call it de minimis, but it is
It's
not
small.
material,
Yeah,
it
like-
is small. I know we don't supposed to totally do this, but I look at the common good of New Canaan and our community. This is positive to the community. I mean, I know it's not written in the law but the homeowner seems to be respectful and.
If it was a bigger area, I think I'd
Yeah.
say no, remove it, but again, it's. And if it was footprint, it might be different too,
Right.
but it's a pretty small area on someone's roof.
Right. This was done as inobtrusively as.
That's what I'm saying, it's as inobtrusive as possible.
By luck.
Yeah, by luck. From a moral standpoint, I have no qualm telling them to remove the bedroom.
So I just quickly on our GIS looked at 57 Brushy Ridge, five Nutmeg Lane, 39 Brushy Ridge, and 36 Brushy Ridge. 2 of them were 3 bedrooms and 2 of them were 5 bedrooms. And they're in the half-acre zone.
I mean, it's neither for nor against, it's consistent, it's in the
Yeah.
middle.
And you just have to drive a half a mile and you look around and you say, this is what I'm gonna aspire to, right?
Yeah, exactly. Just go up the hill.
Okay, I think that we. Well, if anyone else says anything.
You're comfortable with it?
Yes.
I'd rather continue it if, anyone needs more time.
No.
No.
Alex, you're okay?
I'm okay.
Okay, Fair, is there anyone here for this? No, anyone against it? No one on Zoom? Who's that one person on Zoom?
That's David.
Are you against it?
No.
No? Okay. I move that we close the meeting and we vote on this. Do a long second. I guess we don't have to, but.
I second it. Rich Ferry too.
So we're gonna move, we close the open session at, just the one.
Can you stop sharing your screen?
I would move that we grant the variance. Oh, sorry. This is Jessica Cardin. I'll move that we grant the variance based on the unique hardship that runs with this particular parcel based on the shape of the lot, the topography of the lot, the wetlands of the lot, and based on the small nature of the ask and request for the variance.
I amended to add to it the be consistent with the intent of the regulation.
Agree, exactly, the intent of the regulation helps to drive this decision.
I second the motion.
Okay, let's start voting. Cynthia,
Dull in favor.
Cardin in favor?
Cash in favor?
Carry two in favor.
Snyder in favor.
Good.
Thank you.
Thank you.
Thank you.
Yep.
Why is everyone looking at me?
Are we all fair?
No, we got approval of minutes and other matters.
That's what we're looking at.
That's why
I don't read the agenda.
I'm afraid to say anything. I'm gonna get me in trouble. Okay, Luke?
Yeah.
I've
Don't
read,
have any comments from minutes?
no, I've read, no comments.
Move we, approve the minutes
Yeah.
prior meeting.
I second.
Let's vote. Alex, you start this time.
In favor of approving the minutes.
Carry two in favor.
Cash in favor?
Cardin in favor?
Dull in favor.
Okay, and then,
Business?
yeah, so one very quick thing. We don't have any new applications next month, but we may have to do an executive session for the Pastures Lane appeal that was from last fall. So, well,
Didn't they sell that property?
no,
I thought I read where they did sell that extra.
It's next
No.
door, the
Yeah.
vacant lot.
So we may have to do an executive session. Does the board want that to be a remote meeting?
In person. Once.
I'm indifferent.
Okay, if the town attorney is unavailable in person, do you want
Have
to
him
just
on
be
Zoom.
on Zoom?
Yep.
Just tell them to be on the Zoom, right, on the tab.
Okay, but so are we coming in person?
I think we might as well, so I think it's preferable, I think, for all.
Okay.
I mean, if someone needs to be remote, I'm fine with it too, but if that's not an issue to anybody.
And so
Okay.
an executive session, that means we're meeting, but it's not to the public, it's not on Zoom.
Correct. Okay, so we'll let you know. We're not positive if there will actually be an executive session at this time. But we will let you know. So there's a chance the meeting will be canceled, but please keep the date open. We'll let you know as soon as we know.
And if it is, can you just set up the Zoom mechanism just in case for work or something?
Yeah, of course. So Zoom is always available.
Okay.
Yeah, so that's
Fine.
always an option. That's all I have.
Can you
Okay.
confirm that the placeholder dates right now are October 6th, November 3rd, and December 1st?
Yes.
Okay, I'm just reconfirming.
That's all I have.
Well, thank
Okay.
you, Sarah.
Is the meeting adjourned?
I move to adjourn the meeting, all in favor?
I.
Sure.